Hello, everyone, and welcome back to this episode of the Vancouver Life Real Estate Podcast and YouTube channel. Today, we have a very special episode and a special guest. Jeannie Ball is joining us today, who has a fascinating story about her rental property, her experience dealing with particular tenants, but it's also like dealing with the Residential Tenancy Branch here in British Columbia, about losing a hearing at the tribunal and then escalating it to the Supreme Court of British Columbia and the outcome there. And Jeannie exposes a potentially terrifying practice currently taking place at the RTB that may dramatically affect thousands of cases and their outcomes over the past couple of years. The lessons learned during her journey are being shared here today, and the advice can potentially help a lot of others, including landlords, tenants, anyone involved with the RTB, and those interested in ways to dramatically increase our housing supply without having to build more homes. Yes, you heard that right. We've got a theory here. So Jeannie's goal in sharing her story today is that her case against the Residential Tenancy Branch be used to change the dialogue and force the RTB's hand. Because quite simply, they need to improve and encourage rental supply instead of the current deterrent effect that they have in place. Now, real quick here, just before we get into the interview, if you are considering buying or selling a tenanted occupied property, well, it requires a nuanced understanding of meticulous navigation of these additional considerations unique to this type of transaction. Well, fortunately, both Ryan and I are experts in this area. And if you are considering buying into or selling a property that is currently tenanted, we highly encourage you to contact us in advance so that we can help you avoid all the potential landmines, some you'll hear of today, that come up in a transaction like this. So now let's get into today's interview. Jeannie, welcome. Thank you so much for being here today.
Thank you so much for having me.
So it's a very fascinating story. And I think, like all great stories, why don't you start at the beginning and tell people about the property and the tenants in place, and we'll just kind of start working through what got us to where we are today.
Okay, so essentially, I'm lucky enough to have a husband who purchased a property when he was in his 20s, and that's the house that is the subject of this whole dispute. We essentially bounced around quite a bit while having tenants in the house, and in about 2020, during COVID, we realized that we needed a home for our family. We had had twins. And it was time. Unfortunately, the economics and the circumstances of the housing market in the Cowichan Valley at that time didn't allow us to purchase a house at the escalated prices. And so we were looking to evict our tenants so that we could make this our family home. And just to tell you a bit about the house itself, it's in town in Duncan in the Cowichan Valley for folks who are familiar with the island. And it's what the neighbors joke about calling the area as the Oak Bay of Duncan. So they're mostly larger properties. This property is about 0.2 of an acre. Older houses. This house is about 100 years old. And it's a 3-bed, 2-bath home with a detached shop and a fenced backyard. So lots of space, very suitable for our family at the time.
Perfect. Can you share a little bit about the tenants, I guess, how you found them and how long they were in there prior to you wanting to move back in?
Yeah, so there was a number of tenants, but these particular tenants had been here for about 9 years.
Wow, long time.
And so they had a small family, and our relationship with them was, reasonably, it was civil. We had no disputes over those 9 years. Mike came and went from the house probably, I would say more than once a year. We fairly sometimes he was here as much as monthly because at times the tenants were challenged in making their rent on time. So he'd be coming by to pick up checks. But for the most part, it was a good relationship. We were kind to them and, did lots of repairs and things over the years.
Okay, sounds good. And then as a landlord myself, and as is Ryan, how often were you guys doing property checks, checking in on things, and essentially checking in on the health of your own investment, your own property?
Yeah, I mean, Mike did most of that work, but he was here, sometimes monthly because, of course, he was picking up late rent or attending to other things. But, at certain times he did work in one of the bedrooms, one of their boys' bedrooms. He renovated the kitchen and was here quite frequently, daily during that period of time. And otherwise, I would say it would be a stretch if he wasn't here over any 12-month period.
So frequent, very frequent. Yeah. So a lot of surprises in that ways, in many ways, you probably could have seen coming to some degree, but probably not what you had imagined.
Yes.
Yeah. Well, maybe kind of get into some of that story here about where things started to turn.
Sure. Yeah. So, essentially, we felt terribly about evicting the tenants at the time. We did all the proper things. We served the appropriate notice, used a process server. We gave them a little bit of additional time than what was required. And as well, in addition to forgiving the required month's rent, we also halved their last month's rent just to give them a bit of an extra advantage in the market at the time.
Yeah.
And then when we came to move into the house, we noticed that it was, there was a high level of dampness in the house. We started to pull up the carpets, which is something you do when you're moving back into a house, and realized that there was a significant amount of damage to the floors from a leak that had been occurring. And it seems like it was a slow leak. It had been happening likely for many years, but it had destroyed the supporting beams and the structure of the supporting the main floor of the house. Wow. And so, given the age of the house, you can imagine back then the codes were different. The spans were larger because the beams were essentially old growth trees. And when you start to peel back that onion, you can't just rebuild it with current day lumber the way that it was. So my husband, Mike, at the time, he's not working as a carpenter anymore, but he was, and it still is, a red seal carpenter. He was able to spend the time personally to jack up the house himself, replace those supporting structures to current day code. He had to go get a permit to do that, and essentially end up replacing a number of the exterior walls of the house as well, in order to meet the code requirements and things like that.
And for clarity's sake here, there was no mention from the tenants about any issues, leaks, or potential damage. Okay, so it was a full surprise.
And the process that followed this doesn't really give us an opportunity to have a dialogue with them to know whether, it was something they missed or if it was something that was known to them. But you can imagine there's so many tenants current day who wouldn't share those things because, of course, they're afraid of being rent evicted or the landlord taking the opportunity to get them out of the house. So that took Mike a long period of time. We were only partway through those structural repairs. We had no intention of doing renovations or any of that kind of work to the house, but the structural issues were so significant. And so we had evicted the tenants in January of 2021. And so in early June of 2021, they filed with the Residential Tenancy Branch. And their claim was only specifically that they wanted $16,200 because we had evicted them and hadn't moved into the house. And attached to that claim was 4 documents, most of which was the letter we had served them, the actual tenancy agreement that we'd had with them, and the notice that comes with that letter from the RTB that says, this is how you dispute this claim.
Gotcha. And just to also share here, the amount that they made in their claim was equal to 12 months rent, if I remember correctly, because that's the RTB's recommendation.
Correct. Which is that's the law of the time.
It's kind of hard to move back into the house when you have to replace the supporting beams and exterior walls of the home. And that would logically take some time to replace and repair before you could move back in.
Yes, definitely. And the kitchen was on the upper floor above the bathroom that was downstairs. So there was a period where there was no space between what was used to be a kitchen, and you could fall, right into the bathroom that was downstairs. So with
Wow.
2 5-year-old twins at the time, it wasn't really somewhere you could have kids underfoot.
Yeah.
Yeah.
Well, I got a 5 and a 7-year-old, so you're speaking my language.
Oh, I love it.
Not that you would have had to, but I guess there was no communication with the tenants since they were evicted in regards to, hey guys, like, why didn't you tell us about this? Or we now have to do a major reno just to have the house habitable.
No, there's no process under the Residential Tenancy Branch, service, if that's what you want to call it, to encourage dialogue between tenants and landlords. I mean, it does say try to resolve the dispute once it's filed, but there's no opportunity for us to make those explanations to them. So, they would have been just walking by the house and seeing the work that was, being done and potentially making assumptions. I don't know. But again, their claim was limited to that we hadn't moved into the house. And so the Residential Tenancy Branch rules of procedure and their guidelines all say, you can only defend yourself, so you can only submit relevant evidence that's specific to the claim that's filed against you. And so in this case, our evidence and ability to defend this claim was limited to why we hadn't moved into the house. So Mike articulated the structural damage, and I should say Mike did essentially all of the work leading up to the residential tenancy hearing. And submitted evidence, submitted photos of the kitchen where you can look into the bathroom downstairs, submitted photos of the structural damage, all of these pieces. And in his claims, he made no reference to us intending to renovate. He made no reference to us being in the act of renovating after we moved in. He simply spoke to the structural damage and the things like Ryan mentioned, that you can't move into a house in that state.
No.
So fast forward to in the hearing itself, there was some interesting things happened that we didn't expect. So for instance, the arbitrator arrived late. The arbitrator didn't introduce himself. So it was almost unclear in the hearing whether we were speaking to an agent from the Residential Tenancy Branch who was setting the stage, or an arbitrator themselves. And then the arbitrator went through things like, you can't record the hearing. This was before hearings were provided. And he also went through, specifically directed us not to review our evidence, but to speak to, our story and, what had occurred. And the tenants said very little. They essentially echoed what the claim was that we knew it to be, which was they wanted the $16,200 for the 12 months and that we hadn't moved into the house. And then Mike described the structural damage and went through, us trying to do this work during COVID, no access to, you remember 2021, this hearing was in November of 2021, but it was April of 2021 when we discovered the damage. You couldn't find a contractor to do this kind of work in a 100-year-old house when they could be building new construction. You couldn't find supplies, all of these things. I think that one of the comedic moments in this whole story is that our cabinet, so the kitchen's destroyed, we've got all these brand new cabinets, they're stuck in the Suez Canal with everything else. Right?
My goodness.
So there wasn't much we could do to get into the house faster. And so the arbitrator is expected to weigh, was there an extenuating circumstance? And ultimately, his finding was he didn't believe that there was extenuating circumstances. So he overlooked the structural damage. He overlooked the lack of access to supplies.
But the supply chain issue wasn't unique to you. That supply chain issue was unique to everybody. So that's a bold claim. Anyhow, I'll let you carry on. Just a bold claim, but...
Yeah, and so when we read his finding, the thing that stood out to us is he found in favor of the tenants. He ordered that we pay $16,200, and it was on the basis that we should have known that we intended to renovate, and therefore we should have filed the notice of eviction based on the Section 49.2 of the Act, which is, the Residential Tenancy Act, which is with the intent to renovate. And so we saw that and thought, well, this is weird. Nothing. There wasn't even the word renovation in the claims against us, nor any, the 4 documents of evidence that we saw. There was no discussion of renovation in the hearing. Where did this come from?
But you're also not allowed to. Did you say you weren't allowed to present your evidence either?
He instructed us not to go through our evidence. Yes.
What kind of court of law is this? Anyway, sorry.
I know. I mean, at this point, we didn't know. So, fast forward for the viewers, it turns out that the tenants had submitted a significant amount of evidence that we did not know about. And that in that evidence, there was claims of renovation, and that it spoke to renovation multiple times and essentially put forward the allegation that we had renovicted them. But we had none of this evidence. And even when we received the arbitration decision, we didn't have this evidence. So in our minds, I thought that the arbitrator didn't have enough evidence to decide against us. My mind is spinning on, this dialogue you hear about the Residential Tenancy Branch being unfair and biased against landlords, and that the arbitrator himself made up this claim of renoviction because he didn't have enough to side against us based on the facts of the case. And so Mike and I, of course, put our heads together and decided we have to put on our adult pants and file a review, right? So we filed with the Residential Tenancy Branch an appeal because that's the next stage in the process, and submitted the evidence. And in researching, we only had... There's a whole calamity of other errors and mistakes in this process for us, but I won't get into those just for the interest of time. But essentially, we had about 30 hours to file our claim because of misinformation provided to us. But in the research in those hours, I realized that Section 49.2 that the arbitrator had said we should have filed under actually didn't exist until 6 months after we had evicted the tenants. It was not in the law. It was not in the Residential Tenancy Act. So clearly there was no way for us to have done that. And in addition to that, it wasn't in place until after the tenants had filed their claim. So certainly they couldn't have filed a claim based on that. And the residential rules of procedure also say that you have to file, you're bound to what's in your initial claim unless you go through an amended claim procedure, which clearly hadn't happened. So we drew this to the attention of the review arbitrator in our arguments and raised the issue that we didn't know anything about renovations or a renoviction claim until after the hearing, which is unfair practice. And the review arbitrator sidestepped those. We had put in a couple of other reasons for them to overturn the decision. But essentially they sidestepped those arguments and upheld the original arbitrator's decision. And so at that point, there is no recourse except to go to the Supreme Court. So I did speak to a couple lawyers at the time, and on the basis of just, what I described, thinking that the arbitrator just wanted to decide against us and was biased, most of the lawyers I spoke to said, it's very unlikely you will win. The Supreme Court, you have to have a very, very strong case in order for the Supreme Court to overturn the decision of a lesser court, like a tribunal such as the Residential Tenancy Branch. And so, but Mike and I, knowing that something was really not right and not feeling good about it, and knowing that we had been good landlords to these tenants and other tenants at a subsequent rental property for over 15 years, thought we have to go forward with this. So we filed a petition to the Supreme Court, and what happened, and that was on the basis of bias, essentially. What happened was we received disclosure from the Residential Tenancy Branch, the lawyer of the Residential Tenancy Branch, as part of the hearing preparation process. And in that, we were able to review all of the documents and information that the arbitrator saw. So all of the subsequent evidence that the tenants had uploaded into the Residential Tenancy Branch's online system, which, as I described, made all new claims, a claim of renoviction, which we didn't know about, and all sorts of additional evidence. I think they made approximately 9 additional submissions on different dates with over 20 pages of additional photos and evidence that we never saw.
Jeannie, This sounds like it sounds like you're opening a can of worms here. Or it sounds like to me anyhow that we talk a lot about, when you go to court about due process and certainly the presentation of evidence. How did it go? How did it get or require you to go to the Supreme Court before you saw evidence that was coming in from the other side? I mean, how this to me is I don't understand the methodology. Maybe it was explained to you, but maybe you'll get into that. But to me, this inherently feels like an unfair process. But anyhow.
Yes. And I mean, ultimately, that was the Supreme Court judge's decision, was that the procedure breached the rules of natural justice and procedural fairness, and that the arbitrator's conduct breached all of those things, that the Residential Tenancy Branch did not act fairly. And that's why that judge, Justice Masonville, overturned the decision. But in my research, so like speaking your language, Ryan, of like, how could this happen?
Yeah.
I, as a wife, I thought, oh, wow, Mike, what did you miss? Like, we must have had access to this. I can't imagine there's a tribunal process or a court system in Canada that would allow something like this to happen.
What? Where did you check your junk? Did you check your junk mail?
Yes, exactly. Give me your login. I need to go through the system. I couldn't find anything. So it's like, this is a real husband and wife scenario. So I called the Residential Tenancy Branch because I thought Mike must have done something wrong. No, I shouldn't have thought that. Mike is a brilliant person who is super good at pretty much everything and doesn't miss these kinds of things. But when you're comparing your husband to the judicial system, which one's most likely has made the error here? So I called the Residential Tenancy Branch, and sure enough, I think I sent you a screenshot of this. I don't know if we're able to share it, but the Residential Tenancy Branch officer described to me that no, all participants are completely blind to what's submitted through the system to the arbitrator. And I've heard this multiple times, that the Residential Tenancy Branch disclosure procedures function on trust. So good faith that the participants will serve the documents as instructed. And there are no checks and balances. So there's nobody at the Residential Tenancy Branch that goes through to assure this. There isn't a process by where the arbitrator at the beginning of the hearing is required to review the documents.
This is terrifying to me. It's absurd. So there's no discovery from both parties. It's done on an honor system for some reason. And they could literally upload things like, yeah, they came in and killed our dog, and you would never know about that. And then the judge would base the ruling on it, thinking that, okay, everybody has uploaded these documents honorably, so it must be fact.
Yes. And I mean, as an example, the dog example, these tenants had actually submitted a photo of the fridge that was in the house, which was fine. But in the commentary that they uploaded it with it in the Residential Tenancy Branch system, they wrote, this is the fridge that the landlord gave to us secondhand, stating he found it on the side of the road and it wasn't good enough for his family. Like, highly prejudicial things.
Kidding. And baseless unless you have some sort of evidence to support that.
Yes. And should not be considered unless we have an opportunity to show receipts of the fridge that we bought and demonstrate that, in fact, that was not true.
Yeah. And how would you know to provide that if you don't know what they're submitting? And on what kind of boggles my mind is, I'm not a lawyer, and my legal education is very limited. But what I will say is, I thought a big part of understanding one story or the other involves some form of cross-examination, some form of, well, you submitted this, and so I'm going to question you on this, and you submitted this, so I'm going to question you on that. And then you would have a cross-examination from both sides of the party to figure out whether or not this is all lining up. But not to have that process at all, I don't even know where to begin with this. It sounds just like they dropped part of the judicial process to increase the speed of getting some of these things dealt with, but in doing so, removing significant rights to the people that either are the landlord or the tenant, for that matter. It's crazy.
Yeah, and I think speed is a key piece here. So in my conversation with this residential tenancy branch officer, to say, like, how could this happen? There's really no way. So what was I to do? Like, could I have asked the arbitrator to review every piece of evidence at the beginning of the hearing? And she said, oh, the arbitrators would never have time to do that. And I said, okay, so like, what about a clerk going through this? No, we're not staffed for that. And I have to say, in this whole process over 2 years or whatever it's been, I've had many conversations with the staff at the RTB, and they've all been wonderful, well-meaning people that I think are working very hard to do their jobs and serve the public as best they can. But they are also honest about the realities of their situation. So my next question to this officer was, okay, well, clearly there's reams of information. Well, sorry, that's an embellishment, but there's ample information that we did not see that was held against us. Surely the director of the residential tenancy branch wants to know this so that I don't have to continue forward with my petition to the Supreme Court and use up the court and the judicial system's time, right? Like, the director needs to know that there's this gap in the process. And she said, oh no, the director knows. The staff all know. The arbitrators know.
So we're just operating with a broken system.
Yes.
So Jeannie, did you discover, has this practice essentially been in place for many years, or was this almost a result of COVID and a new system they have in place?
I think she said at the time that the system, she made her comments about the system, and then she said, yes, it's not great, and it's been in place for about 2 years at this time. So this was, I think, March of 2022 that I was speaking to this officer.
Okay. So it's a relatively new practice or process, and one that seems clearly untested, but is in place and could be in place still today. And I'm trying to run the numbers here. Like, how many hearings at the tribunal will have had decisions made based on this system?
Yeah, I mean, this was part of after we amended our petition, and so that we were going to the Supreme Court now on a case that was procedural unfairness because of this gap in process. I did a bunch of research on that. And so I found a BC ministry communication or memo that went out, public communication, that spoke to the number of cases that are heard by the residential tenancy branch. And I think it was from December of 2022. And it said that the residential tenancy branch processes at that time about 20,000 cases a year. So they have 20,000 hearings, which, you multiply that by 2 years, that's 40,000 hearings. Multiply that by 2 potential participants, that's 80,000 people who potentially have been through a hearing with the residential tenancy branch in that 2-year period and don't know the evidence or the claims against them.
That's 55 hearings a day.
Yes. I mean, 55 hearings a day also gives you a sense of why they might be spread thin, depending on how many arbitrators they have and how much. I think, part of coming forward with this is to ask the province to better resource them. Like, we can't go forward with a system like this.
Well, it's inherently unfair.
Yeah. I mean, I did follow up with the residential tenancy branch just this last week and spoke to an officer again to ask about the process and whether it had changed. And essentially they said, no, it has not. People can still submit information into the system. It's still based on the honor system, whether those documents get served to the other party. And I said, well, here's my experience. I told them a little bit about my experience. And I said, how would I go into a hearing and know that there was evidence against me that I didn't know about? Or how would I make sure that I had it. And the officer's response was, well, when the other party starts speaking to the evidence that you haven't seen, then you would raise that to the arbitrator's attention. And when I then, yeah.
But the arbitrator,
after they told you to not talk about the evidence that you submitted.
after the arbitrator also
Fantastic.
has the evidence as well.
Mm-hmm.
But, like, the arbitrator's the one sitting there with the evidence presented from both sides. And wouldn't there just be one step to say, hey, listen, this isn't lining up with this, and I'm, there should be everything that gets submitted in terms of evidence should be available to both sides to either contradict or confirm whether or not that evidence is true, or at least provide a case against it or for it. I'm baffled that this is left up to an honor system when there's a lot of incentive and motive for people on either side of this transaction to not honor the system.
Yeah, I mean, in this case, our tenants had known us for a long time, right? I think they know that we're honest people. I think that they trusted Mike over that period of time. We had no disputes, but I think $16,000 is a pretty big carrot.
Huge.
And then I imagine people in Vancouver, right? Like, if I had a house like this in Vancouver, I mean, what would the rent be? 3 bedrooms, 2 bathrooms, fenced yard, 0.2 of an acre.
You're over $5,000 easy, depending on location.
$5,000 a month. Yeah, so you're talking $60,000.
Yeah, well over $60,000. Why would a tenant not proceed with that? And I mean, I do also have to say that most people are honest. Most people don't go into a process like that, this intending to cheat the system. And there's actually a Residential Tenancy Task Force that Premier Horgan had set up when he was in charge, that looked into this. And their findings were most tenants in BC are honorable people who just simply need a place to live. And most landlords in BC are honest, conscientious, considerate, thoughtful people.
Which, if I can interject, is that not all the reason in the world then to allow both sides to see the evidence presented against them? There's a logical or rational breakdown here in terms of process, if that's the finding.
Yes.
Then if that's the finding and you're an honest person, then you should have no problem with the evidence I'm presenting. Right? So why am I not allowed to see it?
Yes. Yes. And why is the system, I mean, if you go into a regular court hearing, there's a lot of process around serving of documents. And I get that as somebody who needs a place to live, or a landlord, you're not necessarily versed in the law and the proper serving of documents. And so I think maybe this was a compromise for the Residential Tenancy Branch to bridge that gap and make it easier for people. But when in that compromise, you create this kind of pitfall, it's nonsensical and unreasonable. And it would be better for them to resource themselves in a way, or the province to resource them in a way where they can do that serving of documents for the participants to ensure that things like this doesn't happen.
Absolutely. And good for you for escalating this. And I mean, ultimately, it sounds like the Supreme Court ruled in your favor. And from what we've learned today, seems to be the correct call. And I mean, kind of walk us through a couple of things here. The claim was $16,200. Escalating to the Supreme Court, I imagine that comes with some pretty significant costs, both financially and probably emotionally and mentally. What kind of timing and I guess, tolls and costs come with taking a case to the Supreme Court in BC?
I mean, for me, I would say you have to read all the acts, right? The Administrative Tribunal Act gives the court, the tribunal of the Residential Tenancy Branch, the jurisdiction. Need to understand that. Need to understand the Residential Tenancy Act and all the court processes, right, around proper serving of documents and how to write a petition and all of these things. Now, the courts were really helpful, but I would say I took 2 weeks of unpaid time off of work and easily spent 2 to 3 weeks of my own vacation time, plus most evenings and weekends for I would say the better part of a year. And we had a gap. I mean, our case was, what was that, a year and a half, almost 2 years before we were at the Supreme Court. Some of that was because, life things happened and we had to defer the hearing. But yeah, it went on. And it was, thankfully, Mike and I have a very strong marriage. We like each other a lot, so we could get past some of the tensions. But yeah, it was not an easy go. Many, many, many sleepless nights. Lots of time thinking, should we even do this? But ultimately, when you think about the impact this has, when you hear the dialogue on CBC about the number of people that don't have houses, who have jobs and have nowhere to live, the number of people, the economic circumstances and the amount that they're trying to develop when the economics don't really support it. And you can look at this and go, if we can get the residential tenancy branch to be more fair, then there are many, many landowners out there who have existing suites in their house, or the ability to create those suites and aren't doing it because they don't trust the system.
Correct.
Right.
That is the biggest statement I think that I want people to take away here. Because it's, the RTB does not have the most favorable image here in BC when it comes to landlords, right? I mean, I know I invest here in BC and in Alberta, and I know how much the rules favor one or the other based on which province you're in. And so the story that you're saying is actually really quite resonating in the fact that you're right. People are literally so afraid of the RTB, they will not take product to the open market as a rental unit. There could be hundreds, there could be thousands of potential units there that people own or can convert to a rental that are sitting there saying, it's not worth it. Because if I happen to somehow get the wrong tenant, I am almost all but guaranteed to lose probably tens of thousands of dollars. So I'll just leave that space vacant.
Yeah, like why take the risk? And I have to say, I had to eat my words in a number of conversations I had over the years that I was a landlord, because I know, 6 people on the island who have houses that, their kids have gone off to university, and they talk about putting a suite in the, 3 bedrooms, 1 bathroom downstairs, might as well suite it and get tenants in it. But they always stop at, I don't trust, I hear these horror stories about the residential tenancy branch. And I always said to them, do it. It's so rewarding. Like, in Canada, we care about each other. It's part of our culture. There's value in it. And then there's, monetary parts as well that are helpful. Pad your retirement, whatever you want to do. But I in the end, I ate those words. I know another 6 folks in Vancouver in the same situation. And I think, they're in Kitts and Burnaby and Marpole and places that are really great areas for people to live and be able to commute to downtown. But they're just sitting on a vacant suite because they just don't want to bother. And there was a columnist from the Vancouver Sun who picked up the judicial review decision, Justice Masonville's decision, and published it in the Vancouver Sun at the beginning of January. And in the comments that people posted in response to that article, you can see there was like 3 or 4 people right there, total strangers, who were saying, my parents have 2 suites in their house, but they're not renting it because they don't want to take the risk. And so, I'd like to get that message to folks like Ravi
Baines,
Halon, and other, David Eby, and folks that actually can control the fairness at the residential tenancy branch.
Jeannie, a question for you. During your process, did you consult with a lawyer at any time?
I had a friend who was a lawyer who gave me some guidance about how to get through the initial petition filing process for the Supreme Court. And I touched base with him a couple of times, mostly on like filing and, rule procedure issues. Yeah.
The reason I ask is because it probably makes it's also a bit of another circumstantial reason as to why, even if you are going to go through the RTB process, even if you have to spend a couple $100 to talk to a lawyer about the position and how this is going to work and whether or not things are fair, there may be a case for some type of legal representation too in this, especially if it's unfair. If it's inherently unfair, having at least somebody who understands due process and who can defend you in that respect. I guess it's going to be relevant to the size of your claim as well. But generally speaking, it sounds like, a lawyer at the very least could have stepped in and said, hold on a second here. This is going down the wrong path right from the get-go, and this is completely unfair. I just wonder if there's would you condone that, or would you say yes, like, hey, listen, like, you need to consult with some professionals here too?
Yeah. I mean, let's assume that I never have to do this again.
Yes. Yeah.
But if I did, yes, I probably would get a lawyer to do the work for me. But the reality is, I spent over $2,000 just on photocopying and binding costs doing it myself.
Oh my gosh.
Wow. It was well over $16,000 for lost wages and all those things for me to run the case for us myself and stumble through all those things. I can only imagine what it would have cost to have a lawyer.
Of course,
and
totally.
Unfortunately, the criteria that you need to meet in order to receive costs from a tribunal like the Residential Tenancy Branch is such a high threshold that it will be extremely difficult to get any of those costs back.
No kidding. Well,
Yeah.
After all this experience and all this time and essentially education that you've now obtained, what advice can you share with homeowners, landlords, or anyone even going through an RTB case right now? What would you recommend or advise to them?
So if I had a do-over and was going through the RTB case again, and actually when I spoke to the officer just recently this week, they said, well, now you could call us and ask us what evidence has been put against you. And he said, we can't go into it in great detail, but we could tell you that there was, 20 documents that have been filed against you, and you'd know that you only had 4. And we could give you some of the descriptions of it. And I said, okay, well, that's helpful. And then you could send an email to the HSRTO or whatever the email address is for the Residential Tenancy Branch and request copy of the documents. And he said, make sure it's labeled well, that it says subject line, attention, urgent, requiring documents for upcoming hearing or something along those lines to catch their attention. And then they would be able to provide you with disclosure of those documents. And so that would be one way. But then, of course, you're receiving those documents likely less than 14 days before the hearing, because that's the last deadline that somebody who's made a claim against you can put in those documents. And if they're new evidence, then you're likely going to have to ask for a deferral. So it's going to delay your timeline too. Or you go in and try not to upset the arbitrator by asking them to go through the documents.
I go in there trying to fire the arbitrator.
Yeah.
Because I say that sort of jokingly, but really I don't, because it sounds and feels like a bit of an abuse of power. If there's no oversight over the person making these decisions or no review process, I don't know how fairness can possibly be equated in the whole process. It's going to be completely left up to the arbitrator, and depending on the relationships or circumstances or whatever that arbitrator believes, they're going to have bias. This is typically why you have a jury, and that's why you have, different perspectives that look at these things. And so it sounds to me, first of all, like a bit of a broken system, but 2, it also sounds like, for those people who may find themselves in this situation, knowing the education and knowing maybe, like you're talking about here, some pro tips to try and arm yourself. So at the very least, you can go into this asking more poignant questions to get to the point of how the discrepancies are taking place.
Yeah. And only if you've watched this podcast do you have that advice.
Yeah,
right? Like,
it's crazy.
There is nothing in the Residential Tenancy Branch. There's tons of guidelines. There's tons of documents. There's tons of reminders that you have to serve your evidence to the other party. But there's nothing that says we work on the honor system. And if you don't check, you won't know.
And I think lastly too, Jeannie, are you able to maybe put the foot on the other shoe, or put your shoe in the other foot and say, what would you advise to tenants going through a similar situation?
Yeah, I would advise the exact same thing. I mean, your ability to defend yourself or to win a hearing, if you're in a situation where a landlord has done something wrong, um, relies on your ability to put forward the evidence and know the other party's evidence so that you can run a strong case and have that dialogue, right, with the arbitrator.
So, Jeannie, obviously, again, with all this information that you've now learned here, I feel like there's a message, maybe for politicians, the public, etc. Like, what would you love to see happen here? How can we help get this out? Who can help you essentially get this word out more? What can we do?
I mean, really, I think I have a colleague who says there's no social change fairy. And I think it's a quote from somewhere, right? People have to speak up as individuals. So I think what I would say to folks, whether they're homeowners if you have a suite and you're not renting it for these reasons, write, even if it's a 4-sentence email to the Minister of Housing, Ravi Khan, and let them know, copy the RTB director, let them know that you would create more housing, you would put this forward, but for the fact that you don't feel that you can trust the residential tenancy branch and you don't want to take that risk. And same for tenants. I mean, if you want the housing supply to increase, there's potentially hundreds of thousands of suites in BC that are vacant because of this reason. We don't know the numbers. I don't know if the government has access to those metrics, but if people tell the ministry that they have that state space available, then they can run the numbers and maybe they can take action. I would really like to see the system become fair so that folks will put their suites available and we can increase this housing supply. And, I listened to Ravi Khan speak, and he focuses a lot about, there are things we can't control, like the economics of development and how long it's going to take to develop things because of some of those reasons. And he's certainly putting a lot of pressure on the municipalities, which is an excellent thing to try and increase the housing supply. I think he has maybe just overlooked that there is supply that's at his fingertips, and that if he can reform the residential tenancy branch to a place where folks will trust and will take that risk, that he has the power to open up that supply. And I don't think he's not well-meaning. I think he seems like somebody who's really switched on, and maybe this is just a gap that they've overlooked. So if folks can help me bring that to our BC government's attention, feel free to include David Eby, then maybe we can turn that tide and essentially help to create that dialogue that landlords are part of the solution here.
Yeah, very well put. And, I had never really seen or heard other comments about the RTB not being to blame, but being a potential solution to helping increase rental housing density and in a very quick manner and without having to build a single property. So this can be immensely impactful. So I really appreciate you bringing this to our attention. Okay, well, thanks again. And hey, maybe for marriage advice too, because she went through COVID and threw a Supreme Court case on top of that and came out still together. So congratulations on that. But no, jokes aside, this was incredibly informative and we really appreciate your time here and, somewhat happy with the outcome, I think. So we will get this posted and you may hear from other people and hopefully we can help spread the word and create some value out there and hopefully see some significant change. I know these things don't happen easy or quickly, but clearly this is a pretty catastrophic issue, I would think. And we will do what we can to help improve this process. So thank you as always for tuning in and have a great day.